Good evening, everybody. Good evening, all. This is Dr. K.L. Chandrashekara, Assistant Professor of Law, Vidyavardhaka Law College, Mysore, affiliated to Karnataka State Law University, Hubli. I'm the participant number 50. My roll number is 50 of this refresher course on environmental science and sustainable development conducted by India's prestigious university, Dr. Babasaheb Ambedkar, Marthwada University, Maharashtra, scheduled on 9th September 2024 to 25th September 2024. Yeah, I've been particularly chosen. The topic for the presentation is the role of MC Mehta's public interest litigation in protection of environment pollution. Yeah, let's begin with a famous profound by the father of our country, Mahatma Gandhi. Earth provides enough to satisfy every man's needs, but not every man's greed. This social imbalance, this environmental imbalance leads to this iconic cartoon written by one of the famous cartoonists of Andhra Pradesh, where this social, political, economical, and environmental imbalance made richer become richest, poor become poorer. So, no words to express and no words to match this iconic cartoon. Yeah, let's begin with the focus of my presentation, that MCA Mehta's public interest litigation in the protection of environmental pollution. So who is MC Mehta? Who actually MC Mehta? That every law students, every law teachers, and those who wants to file a public interest litigation has to know this iconic name, this legendary figure that has filed numerous public interest litigation case in Supreme Court. MC Mehta, Mahesh Chandra Mehta, is a public interest attorney from India. He single-handedly won numerous landmark judgments from India's Supreme Court since 1984, including introducing lead-free gasoline to India and reducing the industrial pollution fouling the Ganga and eroding the Taj Mahal. Yes, MC Mehta is nothing but a Green Avenger. He is popularly known among the legal fraternity as the Green Avenger of India. He devoted his legal career to the protection of the environment, and his participation in several landmark cases has shaped the environmental landscape of the country. He is also known as the Green Avenger of India. He completed his post graduation in political science and law from the Jammu University of Jammu and started his practice in Jammu and Kashmir High Court, and later he moved to the Supreme Court located in the capital city of our country. Yes, the Supreme Court. Why it's important to discuss this landmark judgment delivered by Supreme Court and the public interest litigation filed by MC Mehta. Let's see the Supreme Court verdict, how it has changed India's public interest litigation towards environmental protection. Yes, he began his famous public interest litigation case with oleum gas leak, popularly known as oleum gas leak case. MC Mehta filed a case in the Supreme Court regarding the leakage of oleum gas from the Shriram food and fertilizer industry in Delhi. This case led to the development of the concept of absolute liability in environmental law, making industries responsible for any harm, damage, and disaster caused by their operation, regardless of negligence. You know, this oleum gas leak case on 4th December 1985, there was a poisonous gas leakage at Shriram Foods and Fertilizers industry in Delhi, killing one person and leaving many injured. Mehta filed a public interest litigation to raise the larger issues pertaining to the industrial safety and the right to a healthy environment that is guaranteed under Article 21 of our Indian Constitution. This judgment in the case thus evolved the principle of absolute liability against hazardous industries, irrespective of precautions taken. The instance also highlighted the need for regulatory mechanisms and preventive measures so that the such tragedy does not occur in future. This is not only control, this is not only compensate, even in future also, those industry caused huge damage to the uh, environment. It has to be blacklisted, it has to be severely punished, and they have to pay compensation even the damage has been happened in future also. Let's see with the Bhopal gas tragedy case. This case also very similar, but that is one of the disaster that occurred in 1984 in Bhopal. And move to Ganga River case, one of the famous public interest litigation filed by MC Mehta, where the Ganga River, MC Mehta filed in a case to address the pollution of the Ganga River due to the industrial and sewage discharges. This is one part. And the court issued several directives to control pollution and improve the quality of the Ganga, emphasizing the cultural and religious significance of the river. This is the other part, where the court also observed that the practice of throwing corpses and semi-burnt corpses into the river Ganga should be immediately brought to an end. In the name of a religious ritual, in the name of funeral ritual, in the name of cultural ritual practice, nearby the Ganga River, the half burnt dead bodies or full burnt dead bodies or the dead body, they will be thrown into the Ganga River, where the Ganga River, in the name of culture, in the name of ritual, if they thrown that dead body to the river Ganga, they'll actually reach heaven. This is the practice happen in our country. So MC Mehta filed a public interrogation that has to be stopped in the name of ritual, in the name of religious practice. So these practices polluting the holy river Ganga. So the Supreme Court immediately gave a verdict. So either half burnt dead bodies or the dead bodies are not burnt, cannot be thrown in the river Ganga, because it causes huge pollution in both water, and the people who consumes that water are the people who actually frequently using for other domestic purposes will face severe diseases. So that throwing are actually even the corpse and dead bodies cannot be thrown into the Ganga River. So this is an alarming case that emphasized India's ritual. This cut down the ritual practices in the name of funeral rituals. Yeah, this is one of the famous case filed by MC Mehta. And one more case filed by MC Mehta is the Taj Mahal case, where this case also known as the Taj Trapezium case. Taj Mahal is heritage and legacy of the Indian monumental structure. This case focused on environmental degradation and pollution in and around the Taj Mahal in Agra, India. So within the 3 to 5 kilometer radius, there are plenty of industries, factories that are actually leaking the gases and actually they're dumping the hazardous chemical that causes huge damage to Taj Mahal. The Supreme Court issued various directions to control air pollution and industrial activities in the Taj Trapezium zone within 3 to 5 kilometer radius. No factories, industries, or that factories and industries which decreases, which pour the chemical substances, they will be held liable with the aim of preserving the iconic monument, including closing of all emporia and shops functioning within the Taj premises, along with giving rights to workmen. And MC Mehta moved to one more public interest litigation, that litigation called Stone Crushing Unit case. MC Mehta filed this case regarding the operation of stone crushing units in Haryana. The court directed to the closure of the stone crushers operating in violation of environmental norms and imposed strict regulations to control air and water pollution caused by these units. The stone crushing units not only damaging air but also damaging the water, the nearby river, the nearby pond, the nearby lake has been polluted by the stone crushing works. So due to this public interest litigation, Supreme Court gave a stricter guidelines to stop immediately in operation or activities of this crushing stone works. Yeah, and MC Mehta moved to South Indian cases also. He actually filed one of the famous public interest litigation relating to Tamil Nadu's child labor case. MC Mehta was a state of Tamil Nadu and others in 1996. This case, also known as child labor case, where in Tamil Nadu, Supreme Court constituted a committee to oversee the child labor in match factories along with other hazardous factories. In Tamil Nadu, most of the kids under the age of 14, under the age of 16, under the age of 18, they are working in cracker manufacturing factories and match factories and some poisonous chemicals manufacturing industry, accommodating kids because for lower wages. This committee gave several recommendations to prevent fatal accidents due to child labor. The committee recommended that the state of Tamil Nadu should be directed to ensure that children are not employed in firework factories who are under the age of 14. They cannot be accommodated in manufacturing units. The committee also recommended 6 hours working in a day with child employment in only packing works that easily they can work, and facilities has to be provided with recreation, socialization, leisure, and even education, insurance, and all benefits given under the labor law. So this MC Mehta's case relating to child labor highlighted India's one of the major issue that actually it was raised in Tamil Nadu in match factories and in cracker manufacturing factories. And MC Mehta was a Union of India in 2002 case. It's a famous case, actually made plenty of changes in India's motor vehicle industries. It is also known as the Delhi's vehicular pollution case. This case was filed to address the rising problem of the vehicular pollution in Delhi. The Supreme Court issued directives to regulate vehicular emissions, promote the use of compressed natural gas, that is CNG, and improve public transportation to reduce air pollution in the capital. Because this petrol, diesel oriented vehicles leaks hazardous gases. And MC Mehta filed a case. The country's capital actually polluted with the fog, with this artificial gas, with this petrol and diesel oriented vehicle. So this case actually promoted CNG vehicles. Now you take, for example, Tata, you take, for example, even Mahindra vehicles, even the car and the motorbikes who manufactured in India, now they're promoting CNG. This is an alarming and landmark, one of the highly commendable case made by Supreme Court with the litigation filed by MC Mehta. So almost all the car manufacturing industry is now promoting CNG vehicles. So CNG vehicles have some relaxation even in the road taxes. So because state also have to promote the CNG vehicles. So this is one of the landmark case by Supreme Court that actually made India into CNG, that gas-free and chemical or pollution-free vehicles. So the credit has to go to MC Mehta. And one more case, MC Mehta versus Kamalnath and others. This is actually three doctrine has been made: principle of exemplary damages and polluter pay principle and the public trust doctrine, where the principle of exemplary damages was first applied in this case, where the court held that the court would impose exemplary damages other than the damage one is liable to pay for polluting the environment, so that it may act as a deterrent for others not to cause pollution in any manner. The polluter principle to compensate not only the victims but also the cost of restoring the environmental degradation, and so that damaged ecology can be reversed. And Supreme Court recognized the importance of the public trust doctrine in environmental matters. The court held that the state has the trustee of natural resources is obligated to protect and preserve these resources for the benefit of public. It not only control, it not only regulate, even in future also, anybody commits mistake or damage, they has to pay even for the future also. That's why these principles of exemplary damages, this polluter pay principle, and this public trust doctrine is an absolute liability to the people, to the factories, to the industry who made pollution, who made actually pollution, they held liable, and the polluter pay principle is one of the absolute liability for the offender side. So, thank you for your kind attention. And this is my shorter presentation as part and parcel of the refresher course on environmental science and sustainable development. Thank you, one and all.